Thank you for coming tonight. We have got a packed house, and I am thrilled, and I especially want to thank all of the candidates. This is not an easy thing to do, but it is so helpful to us, the voters, as we decide on who to vote for, and so I so appreciate you all coming. So again, welcome. I'm glad you're here, and let's get started. We're going to begin with giving each candidate a 30-second opening statement. And Judge Richardson, we're going to allow you to go first.
My name is Bert Richardson. I'm a judge. Actually, Gina and I agreed we would both stand up because people in the back row can't see us. I am a judge on the Court of Criminal Appeals. I've been a state judge for 20 years. I was appointed by Governor Bush. I'm a former state and federal prosecutor. I'm board certified in criminal law. I was named a distinguished law graduate of St. Mary's University several years ago, and I've taught at the university level for 15 years. Thank you.
I'm Gina Parker, and I'm from Waco, Texas, and I have a history of being a city attorney, assistant county attorney, and assistant district attorney, and I've been in private practice as well. I have over 30 years of practicing criminal law and handling complex criminal cases. I also want to point out that for more information, I think you have our bios. There's no way in 30 seconds I can tell you everything. I also gave you a handout here that has a list of my qualifications, my conservative credentials. But inside of that handout, I have a really important document called Distinctions That Matter. And that document sets out a real clear differences between me and my opponent. I am the true constitutional conservative in this race.
Thank you. All right, let's get started. Our very first question will be for Judge Richardson. Why are you the best candidate for this office, and name one thing about you that will be an asset, or that is an asset to the court?
I'm qualified. I've handled every type of case the court, prior to getting to the court, they cover 3 types of cases. Death penalty cases, I've done over 50 of those. Appeals, I've done hundreds. Post-conviction writs, which also include claims of actual innocence, I've been involved in 8 of those. What I bring to the table is experience and the ability to get along with my colleagues and get my cases published.
Same question.
Same question.
Thank you. I have experience as well. One thing that distinguishes me from my opponent is I've been both a prosecutor and a criminal defense attorney. So I have more experience on the defense side. That gives me a more balanced perspective and a better understanding of both sides of the case, which I think is important for a judge. So I'm not an arm of the prosecution, nor will I be an arm for the criminal defense bar. So I'll have a balanced approach. Also, another thing that distinguishes me is I have more management experience. I have managed a law practice and a manufacturing company for over the past several years, and those are 2 key differences between us.
Thank you. Currently, judges in Texas are elected by voters in partisan races. However, during the last legislative session, a commission was set up to explore appointment of judges instead. What prompted this, in your opinion, and how might this affect Texas if voters no longer choose judges? And we will let Ms. Parker go first.
That's one of the things that's on my handout, Distinctions That Matter. Judges not only serve on the bench, but we are leaders in our party. Our Republican Party platform says that we support the election of judges. However, my opponent in a recent questionnaire noted that he might lean in the direction of the Missouri plan. That would take power away from you as people. It would take the power away from you in terms of voting. Having lawyers and having big money involved in making recommendations to a governor, whether it's a Republican or a Democrat, is not what we want in Texas.
I think what I said was that I agreed with the governor to form a commission to determine the best way to keep our judges. That has come about because we lost 40 appellate court judges in the state in the last election. I'm open-minded. I'd like to hear what they have to say, but I haven't made any conclusions on that. Thanks.
Judge Richardson, why does case law often appear to take precedence in rulings over the U.S. and Texas constitutions?
I don't think it does. I'd like to give me a specific example, but I don't believe case law takes precedence over constitutional issues before the court. I would just disagree with that statement.
Well, I'm sorry. I do think that does happen sometimes, and it's unfortunate. One of the things you need to know about me is that I served as Phyllis Schlafly's National Judicial Reform Chairman. Also received an award for my outstanding work in support of the United States Constitution. I was involved for this very reason. What you see happening in our court systems, especially in the federal court system, is really problematic. And so, yes, I do believe that happens, and I think it's about the difference between me and my opponent. I am a true constitutional conservative, and I will not legislate from the bench, but uphold the rule of law instead.
Okay, Ms. Parker, this next one is for you. How can judges avoid validating the public perception of a two-tiered justice system, one for the elites and another for the average citizen?
That's an interesting question. I think one of the ways is that we stay engaged. I think forums like this are especially important. So when we're engaged in speaking and traveling, and I think my opponent and myself both have been involved. He's taught school, college, and I've been a lecturer for over 30 years. I've been speaking and educating people about our judicial system and what our rights are. And I think that's one way, is we're involved. We show up for events like this. I'm a grassroots activist. My mother was a county chairman. I've been involved at the state party level, and I will continue to do that, not only serving as a judge, but as a leader of this party.
When I got elected in 2014, Judge Uri and Judge Newell and I were the first judges on the court in 10 years, and we all agreed that we needed to give the court a higher profile. I make every concerted effort to get out in the public and talk about the court. I bring classes into the court, educate them, give them tours, educate people about the importance of at least the state high court for criminal matters.
Judge Richardson, what can be done to shorten the judicial process for cases, which are often lengthy and costly for taxpayers?
That's a good question. In our court, we have goals of getting cases out within 120 to 180 days by the time we get them. We have no control over any appellate cases until the pleadings are actually filed in front of our court. As a general rule, I think our court moves those cases quickly. However, there are things beyond our control, such as decisions from the U.S. Supreme Court that change the rules and executions. There's a variety of things that happen in the federal system that change rules and make the cases go on longer. They get remanded, there has to be more hearings. So those are things beyond our control. Within our control, we get our cases out on time.
Could you repeat that question again? I want to make sure I understand.
What can be done to shorten the judicial process for cases, which are often lengthy and costly for taxpayers?
Well, I think one of the things that I've seen in studying the court is that we have the Texas Judicial Commission, and they're moving forward with the e-filing system. That's been implemented, and it's mandated that all counties be participating in that as of January 1st, 2020. That will be a huge difference. Just handling the volume of cases and the paperwork is a challenge for any court, a district court, appellate court, and the Court of Criminal Appeals. So I think improving our technology and some of these things along that line will make a tremendous difference. And then, for me personally, is having a goal of getting my job done on time.
Mrs. Parker, is it necessary to designate crimes differently based upon a protected class, such as a hate crime?
Actually, I totally disagree with that. And in my early years as a prosecutor, one of the things was to try, when we were looking at legislation and involved in that process, was to not have those special designations. It makes it much easier and more effective to prosecute. So I do not agree with that. If somebody commits assault, it doesn't matter what their orientation is sexually, what their color is, what their gender is. So we want to have the laws applied fairly. There is no need for special distinctions.
I'm inclined to agree with her on that. The state is required to prove each and every element of an offense beyond a reasonable doubt. Normally the hate crime, where that special class of a person is just an additional element they have to prove. And they've already proven the offense occurred, so I just don't think there's a need for it.
Okay. Judge Richardson, what is your position on minimum mandatory sentencing?
It's a federal issue. I'm a state judge, and we have nothing to do with that.
Can you state a position?
You know, my position as a judge has to be that that's the law that has been passed, and as a judge, I agree to follow the law, but I can't even follow that law because those types of cases never appear in front of me.
In my early career, I would have said it was a great idea, but after practicing law for over 30 years, I think it removes the discretion from the judge, and every case is different, every set of facts is different. The situations with the victims, the criminal defendants, even their backgrounds. And so it really, my short experience of handling some cases in the federal judicial system, I did not like the minimum sentences. I found them sometimes to be unfair and the results to be very, almost too tough in some regards. And so I think a judge is the best decision maker or a jury of the appropriate sentence.
At this time, we're going to allow each of you to do a 1-minute closing statement. And Mrs. Parker, we will let you go first.
I want to thank you all for the opportunity to be here and share with you. I want to remind you that I'm the true constitutional conservative. I'd like for you to read about me and the distinctions that matter in this race and the literature that I gave you. I want to tell you that I've been endorsed by former Governor Rick Perry, also Congressman Ron Wright, also Congressman Ted Poe, who's previously a congressman, and a number of other elected officials. I've been endorsed by about half of the SREC, a number of county chairmen, and a lot of grassroots activists like you. And I'm proud of those endorsements, and they speak to my credentials and my long history of serving in the party. I've served in numerous capacities. So not only am I competent and qualified, but I'm a true constitutional conservative, and I'm a grassroots activist, and I will be engaged and involved as a leader in this party, helping keep Texas red and making a difference for all of you.
I'm qualified for the job. I'm a judge. I'm not an activist. Judges, according to the Code of Judicial Conduct, have no business being activists in this community. I have presided, prosecuted, and written opinions on every type of case the Court of Criminal Appeals handles in my 20-year legal career as a judge. I've been a lawyer for over 30 years. I'm board certified in criminal law. That is a distinction of less than 1% of lawyers attain. And I'm ready to be reelected. Thanks.
Thank you so much to both of you candidates. Thank you. That's it.